to see that again? Okay. All right.
So, Ms. Teeny, you have a lot of text conversation with Ms. Toner. Some of it is joking. Some of it is more serious, like this string we see in Exhibit 18. Is that fair to say?
Yes, that's very fair to say.
In fact, in these text messages, you talk again about how after that Eater article came out, you realized that what happened to you wasn't an isolated incident, and you became more concerned. Is that right?
That's
right. I'm going to object to the reading again, and standing objection I had on the other allegations.
All right, well, I'll sustain the objection as to the form of the question, and then your objection will be noted.
Ms. Teeny, when you're having these conversations with Ms. Toner in December of 2017, did you know what you wanted to do about everything that had happened to you at that point?
In 2017?
In December of 2017, when the Eater article came out?
I didn't know at that point, upon first reading that Eater article. I wasn't sure what I wanted to do.
Okay. And did you know what your options were at that point?
Objection to the form of the question.
Overruled.
Did you know what your options were at that point?
I didn't. No idea.
That text message, all of the text messages that we've seen, those messages were all pulled off of your phone in the course of this criminal prosecution, is that correct?
Yes.
Was there a court order that you were aware of where you were supposed to turn your phone over to the court for that to happen?
Yes, I mean, there was a little bit of, there was a lot of going back and forth, like, look up this and show us. Well, now look up this and show us. And then ultimately it was like, just give us your phone and we'll look for what we need.
Okay. And your civil lawyers were involved in that as well?
I guess they were involved. I'm not sure to what extent, but
okay.
I think they were present, I think.
Okay. When it came time to, or did you agree to preserve all of the contents on your phone during the course of this case?
Yes, I did.
And did you do that willingly?
Yes, I did.
And after you had already agreed to preserve all of the contents on your phone, at some point did you come into the court and drop your phone off so that all of the materials could be taken off of it?
Yes, I did, yes.
And there was a copy of all of the materials taken off your phone?
Yes.
And that was given to the defendant?
Yes.
And a lot of the messages we saw today came from when you turned your phone over.
That's right, yes.
When all of that was going on, deciding what was going to happen with your phone, did you delete any messages on your phone?
Not at all.
Did you try to hide anything on your phone?
Not at all.
Were you aware that these messages were on your phone?
Not really. I mean, at that point, I was like, you know what, just whatever makes it easier. I can't look, I mean, I can look through my phone as best I can, but if there's something here that needs to come out, just have it.
Did you feel like you had anything to hide that could be found on?
Nope.
And did we see any text messages today that were presented to you in the court that would have indicated somehow you saying to a friend or anyone else that this in fact didn't happen to you?
No.
Or that you weren't assaulted at town in 2017?
No.
There were no messages on your phone presented that say that this was some type of farce that you made up?
Nope.
Objection.
Overruled.
And we didn't see any of those messages today because none of those messages exist. Is
That's
that right?
exactly right, yes.
And the phone extraction is over.
Yeah, I object, because that's, the question's it's suggesting it's our burden to prove something here. And I object and ask that be struck from the record.
Well, so you objecting to the form of the questions then?
And the suggestion that we have an obligation to have produced any evidence in this case, which I think was inherent in that question.
All right, well, I'll note your objection. I'm gonna overrule it. The court's aware of
Thank you, Your
who
Honor.
has the burden. All right, I'll note.
I have no further questions for the witness.
Attorney Fuller, do you want to pick up you have some recross?
Just very brief,
All right, all right.
unless we want to, I don't know what the court schedule would be, but we're going to adjourn until tomorrow. We're going to.
That's what I was thinking, that we would, it's late in the day at this point, we would adjourn until tomorrow. We could pick up your recross at that point.
Well, I can finish my recross and then she can
Be done.
be done. That's
I'd vote for that too, Your Honor.
All right, recross.
just a couple questions. So,
Only copy.
I'm going to offer some records, Your Honor. These were subpoenaed to the.
We haven't seen those.
You haven't?
No,
They were subpoenaed to the court.
they weren't docketed, so we haven't seen them.
Okay. Well, I can do it tomorrow. I don't have to do it now. So, but you testified that you said the Mandarin Hotel.
That's what he said. I have no idea if that's true or not.
Right. But if I told you he wasn't staying there as a Lennox, that doesn't change your testimony. Maybe he said something different.
No.
Okay. Now, you just admitted that you had these serious conversations with Kayla Toner, right?
Yes.
She's the one who told you to play up the story.
Those were
That
her.
text?
Those were her words.
And you said, of course. Those were your words. And that's what you did. You played up the story. So you didn't do that. In those serious conversations with Kayla Toner, who worked at the Boston Police Department, you never discussed with her that maybe you could file a police report. That never came up? So it wasn't until your civil attorneys directed you to do that, correct?
It wasn't all my civil attorneys. It was, you know, when I spoke with Irene at Eater, she had also advised me to
The
get an
reporters,
attorney.
so, okay.
And when I spoke with reporters, they'd advised or asked. I remember one Boston reporter had said, "Oh, have you gone to the police yet?"
So, just to be clear though, the cell phone, the data that we showed you here, that you turned your phone over after Mr. Batali was charged, right? He was criminally charged, then you were ordered to turn your phone over, correct?
That's right.
So all this stuff about you weren't hiding anything, you had an obligation in your civil case to produce relevant information, correct?
That's right.
And you didn't do that, did you?
I'm not sure.
Well, you know what you produced, it was like 30 pages of documents, correct?
That's right.
And so then we went to the BMC judge, Judge Sinnott, and he ordered your phone image, and he ordered search terms on it, and that's where we got that information, after Mr. Batali was charged, correct?
Yes.
And your lawyers vigorously fought that effort, correct?
I don't know about
You weren't in
the
court?
vigor that they were fighting with.
You weren't in court when we had a hearing, and your lawyer didn't argue, and they didn't move to reconsider?
I don't remember if I was in the room or hearing these arguments.
You're not aware of that?
I'm not sure.
And you know the difference between a civil case and a criminal case when you talk to the Boston Police Department in June
No.
You'd sat on a jury in a criminal trial.
I had no idea what the difference was.
You had no idea. You had a civil lawyer who sent a demand letter to a restaurant, didn't you?
I had no idea.
No further questions.
Anything else, Commonwealth?
No, Your Honor.
All right, thank you. You can step down. All right, so I would suggest that we adjourn until tomorrow. All right, so court will stand in recess until tomorrow.